When my family and I were first harmed by a juvenile offender, we found ourselves in the midst of the criminal justice system. We felt many things, but most of all, we felt confused, we felt overwhelmed, and we felt helpless because we were so uninformed. Hopefully today, you are going to receive information that will help you not feel quite so confused as our family did. You, as a victim, have certain rights and responsibilities and duties. And at this point, you may not feel that you should have responsibilities and duties because you did not ask to be where you are today. Your rights are very important, but so are those duties and responsibilities. The duties and responsibilities will empower you to move from victim to survivor. It's very important that you realize as a victim that you are not in this process alone. There are many people that will assist you along the way. In fact, at times you may be a little overwhelmed by the number of people that you will encounter during the process. You may find yourself overwhelmed many times by the information that you will receive. The videotape that you're about to view is meant to be a resource. Use it as that. From time to time, you may find that you must go back and refer to the video. Use the information as you and your family are able to process it. Among the first people who will assist you will be a law enforcement officer and a victim advocate. It is important for you to remember that it is the officer's responsibility to gather facts. It is the victim advocate's responsibility to be just that, an advocate on your behalf. Now, let's hear from an officer and a little later on from a victim advocate about their responsibility in the process.
As a juvenile officer, the largest problem that we encounter is the misconception that the community has as far as how our laws interact with juveniles. The same laws that apply to adults apply to juveniles. A lot of our community think that you can't do anything to a child if they commit a crime, and that's not true. They are required to abide by the laws just as adults are. The difference is the terms that we use in dealing with them and how they are handled through the system because they are children. A child that commits a crime is detained. They're not arrested. Two different terms that mean the exact same thing. A child that's detained will have handcuffs placed on him, will be taken to a law enforcement facility and put through the booking process. Depending on the crime that he has committed, this process could be from as little as just filling out a form for documentation to having his fingerprints taken and his photograph taken. If he's committed a violent crime, such as aggravated assault, homicide, criminal sexual conduct, then he's going to go through the full booking procedure just as an adult would. If he's being charged with malicious injury to property or simple assault, then it's only going to be a documentation record as far as his name, date of birth, where he lives, who his parents are, and the charge that is made against him. The next decision that has to be made is whether or not this child is going to be detained. Now, this is dependent on many factors. The first being what crime has the child committed. Under South Carolina law, a child is guaranteed what is basically a personal recognizance bond for an adult. They are guaranteed to be released back to their parents unless they have committed a violent crime under Section 16-1-60, or there are extenuating circumstances, such as the child has a prior history of delinquency. The community outrage at the incident that has occurred would put the child's life at risk. Or the parents are just unable to control this child. They are completely out of control and therefore would need to be placed in secure confinement until you can get them before the family court. All these factors come into play in determining whether we're going to release a child to the parents at the scene or whether we will take them into detention and place them in a secure facility. If the child is released to the parents must sign a written form that promises they will bring the child to any and all court appearances or any hearings required by the Solicitor's Office or the Department of Juvenile Justice. It's called a custodial promise form. If the child is detained, then they will be transported by myself or another law enforcement officer to the local agency where they will be booked, and then if they're in the Midlands, they will be transported over to the Department of Juvenile Justice on Broad River Road, where the child will be held in the Santee building. That building is designed specifically for secure detention of juveniles awaiting trial. Once we have made these determinations, before we leave the scene or shortly thereafter, the law enforcement agency will provide you with a free copy of the incident report, which documents what happened, who was involved, where it happened, and what criminal charges apply to this particular child. Now, this would not matter whether the child was detained or released to the parents. You would still get a copy of this report. The next thing we would do is contact the local school. Whichever school this child attends, by law, we must notify them that this child has been charged with a crime. Again, this is regardless of whether they're detained or they're allowed to go back home to the parents. The school will then make a determination as to how they're going to address the situation. The next person we would be in contact with would be the school resource officer. If the school has such an officer, this is a law enforcement officer that is at the school. He works there 8 hours a day while school is in session. We would make them aware of this particular child and the charges involved so that if the child's released and goes back to school, they would be aware of the situation. They would be able to monitor the situation. If there were other victims there at the school, the officer would be notified who these victims are so that they could just keep an extra eye on them to make sure there weren't any further problems.
As a law enforcement victim advocate, it is my responsibility to provide support and services to victims of crime. If you are a victim of a juvenile crime, a law enforcement victim advocate would either respond with an officer or follow up behind a law enforcement officer. When an incident occurs, it is important for law enforcement to explain to a victim, if you are a victim of a juvenile crime, why we have or have not detained the juvenile. That process can be confusing to victims and very different than the adult system. So it would be very important to law enforcement for the victim to understand that we have or have not detained the juvenile and why. If we do detain the juvenile, they are housed in Columbia, and we would begin to explain how that process occurs. Once we have accomplished that and educated you on how the juvenile justice system works and the laws behind this issue of detaining and not detaining, then we would begin to try and provide services to a victim of crime. If you're a victim of crime, we would want to be able to get compensation to you. If you have any medical expenses, income lost from work, those resources are out there, and South Carolina has a tremendous amount of resources that are available for victims of crime. It is important for law enforcement to get that information to you as quickly as possible. Once we have begun to provide you that information, it would be important for us to begin to look at what your losses are and begin to document that and begin to explain to you how we go about that process. Once that has occurred, then we will begin to guide you into the next step, whether it be with the Department of Juvenile Justice and what that process will be, or whether it will be with the Solicitor's Office. And we will work hand in hand with that agency to make sure that that connects and that process is clear and understandable for you. It's very difficult, we realize, for people who have been victimized by a juvenile to process this in a whole different way. When you're a victim of a juvenile, often it's a child that you knew, it's a friend of one of your children, it's somebody that was in your home, it was somebody that you loved and cared for, it was a neighbor. And That's heart-wrenching, and we realize that, and we want to support you through that. So it will be our intent to make sure that you understand this process and that you know that what our role will be in this, and that you get the information and the resources that you're entitled to as a victim of a juvenile crime.
The most significant difference in the juvenile criminal justice system from the adult system is the number of options that are available. 70% go to diversion programs. Some are placed on probation, some are jailed, and unfortunately, some are dismissed.
There are many diversion programs across the state that begin prior to the Department of Juvenile Justice intake process. One such program is the Juvenile Arbitration Program, initiated in 1983 through Solicitor Donnie Meyer's office. The arbitration program was created to involve the victim, the law enforcement officer, and the community in the juvenile hearing process. An arbitration hearing is conducted by a trained community volunteer who uses the processes of mediation and arbitration to get everyone involved in the hearing process. The arbitrator conducts the arbitration hearing between the juvenile offender, the juvenile's parents, the victim, the police officer, and maybe other possible parties that are involved with the juvenile crime. During the arbitration hearing, the juvenile must admit guilt and must accept responsibility and be accountable for his or her actions. During the arbitration hearing, the victim gets the opportunity to really tell the youngster how that crime hurt their family, changed their lives, everything about that crime that affected the victim. The victim also gets an opportunity to suggest sanctions for that juvenile so that the juvenile will learn from that crime. The victim's input is very important in the arbitration hearing process. Victim impact statements are sent to the victim prior to the arbitration hearing, and the victims are encouraged to come to the hearing process. The solicitor's office makes all the recommendations for juveniles processed through the arbitration program. During that hearing process, the law enforcement officer talks about the crime, the victim talks about the crime. The juvenile, again, must admit guilt to that crime. If the juvenile does not admit guilt, the case is sent back to juvenile court. The victim would be notified through the court advocate of the court hearing. Usually, parents of juveniles and victims are very pleased with the outcomes of the arbitration program. Through a statewide evaluation last year, 10% of the juveniles that went through the arbitration program reoffended, which meant 90% were successful and did not reoffend. We think part of that reason is because they have to face their victim, they have to accept responsibility for their actions, and the community is involved with that process. If you are a victim of a juvenile crime, I would encourage you to go to the arbitration hearing and talk to the juvenile about the feelings you had when that juvenile committed the crime or how you felt after the crime. Those are very important elements for the juvenile to hear so that they will know that someone is always involved when they commit a crime. There is always a human being usually that has some type of harm that has to be repaired. And we think this is why the arbitration program works in many cases. Now, some cases are not appropriate for juvenile arbitration. Criminal domestic violence cases or criminal sexual conduct cases are not appropriate. And there are several mental health agency diversion programs or social service agencies that could benefit a referral for not only the victim but the offender in those types of cases. But for the first-time nonviolent offense, most of the circuits in South Carolina, 14 of the circuits, have juvenile arbitration where that case would be referred for the first time. If you have any questions about the arbitration program, you can talk to your family court solicitor or your local Department of Juvenile Justice supervisor. If you are a victim of a juvenile crime, I would encourage you to complete the victim impact statement and bring it with you to the arbitration hearing. We feel that it's very important to have the victim's participation during the arbitration hearing process. We feel that that's why a lot of the juveniles do not reoffend. They must accept responsibility for their crime, they must be accountable, and they must face the victim during the arbitration process. The victim is allowed the opportunity to talk about how the crime affected their lives and their family. During a recent evaluation of the arbitration program, it was determined that 10% of the juveniles that were processed through arbitration reoffended. 90% were very successful, completed the arbitration process, and have not reoffended. We feel that not only because of the community input, but the victim's input has helped juveniles not to reoffend and not to have that court record. Of course, the juveniles that do offend will go back to the juvenile court system. The victim will be notified by the victim's advocate for the court system, and the case will be processed in court. Only the first-time nonviolent offender would be referred through the arbitration program.
In order to ensure that your rights are respected, it's important that you realize that there are a few things that you must do. First, you must provide to the agency involved your current address, your full legal name, your current telephone number, so that they might have the information necessary to contact you should any information become available. You also have the right to restitution. You have the right to be present at any plea bargain, at any trial, or sentencing. You have the right to submit a written impact statement. You also have the right to make an oral impact statement to the court if you so desire. It's very important that you exercise your rights, for it is the only way that your voice will be heard. Let's hear from an advocate in the prosecutor's office about the process there.
Once the decision has been made for a case to be prosecuted in family court, it is the victim advocate's job to assist you through this court process. This may be a very frustrating time for you. The case may not move as quickly as you would prefer. It may take several hearings before the case is finally disposed of. More than likely, this is your first experience with the justice system, and there'll be new information for you to process, and it may get a bit overwhelming. But rest assured, your victim advocate will be there to answer any questions and address any concerns you may have. Prior to the case being set for court, there'll be a pretrial meeting possibly set up to discuss the case with you and any possible outcomes. Once the case is set for court, your victim advocate will notify you of each and every hearing so that you can be present at those hearings. And the victim advocate will also attend those court hearings with you if you prefer. You have the right as a victim to make a written and oral statement to the court at the dispositional hearing. This is normally done through the South Carolina Victims Impact Statement form, which you will be mailed. Once you receive that form, it's important that you complete it and return it to the office. This is an important form. It's an important tool that we use in court. It's your voice to the court. It allows the court to see the effects this crime has had on you and your family, not only physically but also emotionally. It gives you the opportunity to make your recommendation to the court as to what you would like to see done, your disposition of the case. There's a place on this impact statement for you to record any damages, medical bills, funeral expenses. Any type of restitution that you may have can be recorded on this form. In juvenile court, if a juvenile is placed on probation, he can be ordered to pay restitution. At the dispositional hearing, if the juvenile is committed to the Department of Juvenile Justice, this form will follow him to the parole board. Once he is released, or if he escapes, the parole board can notify you. Also, if he is placed on probation, this form will be sent to the probation officer so that he can also contact you if there's a need for a rule to be brought back to court for violation of probation. It's important that you record all those medical bills so that the judge can order that restitution. But we do not have to wait until the hearing to check on those medical bills, there's a victim fund available set up through the State Office of Victim Assistance where we can apply for compensation for those bills. We have a compensation form that we will mail you, and if you need assistance in completing that, we can assist you with that. And the form will be mailed to the State Office of Victim Assistance. It's an application process, so they'll look over the form and they'll notify you whether or not you were approved. And if you're approved, then those bills will be covered. As you see, there's a lot of concerns that you're going to have as a victim throughout this process, but your victim advocate is there for you. And if you have any concerns, just remember that you won't be alone.
Once the juvenile has been formally charged, the Department of Juvenile Justice will schedule an intake interview. As part of this process, you as the victim will be notified for input. Now, the intake interview consists of the juvenile and the juvenile's parent or guardian. The intake interview consists of a certain amount of questions, such as the family history, psychological background, any type of medical history, and education. Once all that information is compiled together, all parties will be notified of the court hearing. Now, as the victim, you have the right to know what all parties will recommend prior to the court hearing. Once we go to court and the judge has rendered his final decision, and the judge has placed the juvenile on probation, the juvenile can be placed on probation up to his 18th birthday. As part of his probation, he'll be ordered to do certain things. There will be certain stipulations that he'll have to follow. One of the most important stipulations is a victim's safety plan. A juvenile will also be ordered to complete possibly substance abuse counseling. The juvenile will be ordered to possibly pay restitution back, complete community service, and possibly go to mental health counseling. At any time you as the victim are concerned as to how the juvenile is doing while on probation, what's his progress, you can certainly contact our office and we'll be glad to give you that information. If at any time that juvenile violates his probation, you as the victim will be notified of that violation and of the court hearing. Now, once the juvenile goes to court, the judge can do a number of things. The judge can order that the juvenile continue on probation for an extended period of time. Additional stipulations will be placed on him that he'll have to complete, or the juvenile will be committed to the Department of Juvenile Justice. As a victim, you have the right to contact our office at any time to find out how the juvenile is doing on probation or while the juvenile is in a placement facility or at the Department of Juvenile Justice.
After an evaluation of the offender has been completed, you have the right to know the recommendation of the Juvenile Justice Department before the hearing.
The juvenile justice system is unique. During the last 100 years, our system has developed into a unique program with special laws for the children of South Carolina, with the purpose being rehabilitation and education. This is so the crimes do not reoccur. To that end, the judges in South Carolina have a number of alternatives available to them to hopefully prevent the criminal conduct from occurring in the future. In the next few minutes, I will describe a number of hearings for you that you might attend as a victim of a crime. You should receive notice of those hearings. Normally, prior to a hearing, the solicitor would let me know whether the notice has been sent to you and whether you're in attendance. If notice was not sent to you, then I would stop the hearing and allow you a reasonable opportunity to attend. There are certain time restrictions that I have regarding when hearings must be held. There may be occasions when I have to go forward when you're not there, but I will make every opportunity to allow you to attend, but I must comply with the time constraints as required by statute as well. The hearings that you might attend include a detention hearing. That would be the first hearing, and this would be in a case where the crime may be more serious than others. It may be a crime where the young person who allegedly committed the crime has had prior problems, and the state is asking that he be detained prior to the trial of the case. You would be given notice of this hearing, as I indicated earlier. At a detention hearing, I have two options after hearing all the testimony from the state as well as from the defense. One is to detain the juvenile pending the trial of the case, or two, to allow the juvenile to be released. If I allow the juvenile to be released, I must consider putting certain restrictions on the juvenile that would protect the victim. This would include restraining orders, may include house arrest, or other restrictions as allowed by the statute. The next hearing that you might attend is the adjudicatory hearing. At this particular hearing, two things might occur. One is that the juvenile could plead guilty, or two, the juvenile could request a trial. If the juvenile pleads guilty, I would then go into what's called this disposition of the case, which I'll explain a little while later. If the juvenile doesn't plead guilty, he is requesting a trial. At a trial, there is no jury. The judge acts as the jury and as the judge of the law. At the adjudicatory hearing, I have two options. After hearing all the evidence that's presented to the court, my decision has to be either guilty or not guilty. If I find the juvenile not guilty, he is free to go. If I find that he is guilty, then at the end of this hearing, I would then go into the dispositional phase. The next hearing that you might attend is the disposition. After the adjudication, where I have made the decision as to the guilt, if I have found him guilty, then I have several options. One is to have a community evaluation done, where he stays in the community and the evaluation is done there. During the community evaluation, he is seen by a psychologist, other experts, and a written report is presented to me, and I will use that to help make my decision as to what should happen. The other option is to have a report done from the Reception Evaluation Center. At this particular evaluation, he is detained at the Department of Juvenile Justice in the Reception Evaluation Center, and he again sees psychologists, other experts, as well as they closely observe him during this time of detention. As a result of this evaluation, they provide me with a written report, which I will use at the hearing. Upon the reports being completed, the juveniles return to court and the hearing is held, and you will receive notice of this hearing. At this particular hearing, I will go to everyone in the courtroom and allow them the opportunity to be heard. I will first go to the state and allow them to present their position. That is when you will have the opportunity as a victim to make any statement that you would like to make. I would then go to the Department of Juvenile Justice and let them highlight any parts of the report that they would like to tell me about. Then I would hear from the defense and the juvenile and the juvenile's parents, anyone that they want me to hear as well. I hear from everyone in the courtroom during this final decision-making process. In addition, I have the opportunity to review the victim's impact statement, which you would have filled out. This document assists me in a number of ways. It gives me the opportunity to not only have heard from you in the courtroom, but also read what you said after you had time to reflect on what you wanted the judge to know about your case. In addition, it would let me know about any restitution that might be owed. So there are a number of reasons to fill that form out so that it can be presented to the judge at the time of the hearing. At the time of disposition, I have a number of options. I can, one, place the child on probation. If I place the juvenile on probation, there are a number of restrictions placed upon the juvenile. These would include restrictions that would protect any victim, any witnesses that may participate in the trial, as well as requirements that I hope will hopefully will rehabilitate, educate the child so that we will not see him back in family court. The next option I have is a determinate sentence. I can detain the juvenile for a determinate period not to exceed 90 days. The third option I have is to send the juvenile to the Department of Juvenile Justice not to exceed his 21st birthday. Those are the options that I have during the dispositional phase of the case. The last thing I hope that you will understand is that during the course of the trial, it's necessary that the judge remain impartial and allow everyone to receive a fair trial and allow everyone to be heard. It is necessary for everyone to participate at the appropriate time and as allowed by law. It is necessary that you participate as allowed by law. My goal is to make a good decision, and for me to do that, I have to hear from everyone. And for me to make a good decision, you need to participate.
At the Department of Juvenile Justice, we want to ensure that the juvenile offender takes personal responsibility for their delinquent acts. We also want to make sure that as a victim, you're allowed to exercise your rights. While they're at the Department of Juvenile Justice, we want to change their behavior to ensure that when they come out or released, they do a lot better in the community. Last year, approximately 30,000 kids came to the juvenile justice system. Now, the majority of those kids are diverted from the system. Of those kids that actually come through DJJ, the majority of them are placed under community supervision, under probation, under the watchful eye of a probation officer. And in most cases, they live at home. Now, in some cases, a judge does not feel that the home environment, while that juvenile is on probation in the community, is best suited for them. Maybe the home was a place that actually contributed to some of their delinquency. So a judge may place them in an alternative home. Last year, we had about 800 kids go to alternative homes at the Department of Juvenile Justice. Now, sometimes a judge doesn't feel comfortable with the juvenile in the home or in an alternative home, and they may want to institutionalize them. Our daily population in our secure facilities is about 1,200 kids that actually come per year to the Department of Juvenile Justice in a secure environment. Now, most of the kids that come to DJJ, about 90% of them come for nonviolent offenses. Only 10% are actually adjudicated for a violent offense. Of the 90% that are considered nonviolent, a large portion of them are considered status offenders. Now, these are offenses that, if committed by an adult, would not be considered criminal. Things like truancy, or skipping school, or being incorrigible, out of the control of the parent, or running away. These make up a large percentage of the cases that we have at juvenile justice. Now, I mentioned truancy because I think if you're going to have a reduction in the amount of cases that actually come to juvenile justice, then you have to work closely with truants, because truants tend to be a stepping stone to other delinquent acts. It tends to be a gateway offense. And think about it, if a juvenile is not in school, then they're out in the community. So there's great potential for that juvenile to commit certain crimes if they're unsupervised, such as burglaries, auto thefts, stealing, or they're actually engaged in types of behaviors that are considered damaging to them, such as alcohol and drug abuse or unprotected sex. Now, if a kid does come to the institution, the first thing we want to do is assess them. Now, you've previously heard a little bit about evaluation. When they come to an institution, a long-term institution, they're assessed again. They're taken to an institution where we look at their medical problems, their psychological and social problems. We take a look at their educational level, because many of the kids that we have are deficient in education. In fact, in some cases, they're 2 years behind academically than the normal population in public schools. Based on that assessment, we place the child in an institution where we think they're going to have treatment that's going to be tailored for them. Now, we spend a lot of time with assessment, evaluation, and also with treatment, simply because the majority of the kids that we supervise are going to be released. They're going to be put back into the community if they're placed in an institution. What's the daily schedule like for a juvenile that comes behind the fence in an institution, a secure setting? Well, they're up early. They're up at 6 o'clock in the morning. And like most kids, they have some time to do personal hygiene. They have some chores they have to do, and they're off to school. Now, in school, they spend a full day, just like they do in public schools. The only difference at DJJ is our kids go to school 12 months out of the year. Now, I already mentioned they're behind academically, so it's probably a good thing that they spend more time in the classroom, and they also spend more time developing vocational skills. So some kids will go on and further their education, and some will actually look for a job when they're released from the Department of Juvenile Justice. Once the day is over with at school, they come back to their living space. And it's very important that we do some more treatment with them, some more specific treatment on the problems that we previously assessed. In particular, one of the things that we want juveniles to experience is we want them to understand the victimization process. Every child that is housed at a DJJ institution goes through a victim awareness phase or a victim impact phase, where they actually understand not only the victimization from their standpoint, how they hurt themselves, how they hurt their families, how they hurt the community at large, but also how they hurt the victim. how the victim suffered short and long-term trauma, and it stays with them for a long period of time. And we do this because once they're released, we want them to understand that so they don't reoffend. Now, you have certain rights as a victim with the Department of Juvenile Justice. Once the child comes into the assessment center, we gather information from various entities. In particular, we find out the name of the victim, the address, the phone number, any special needs or requests they may have, and we put that in a file, a secure file, a confidential file that's kept separate from the juvenile's information. We only share the victim information with other entities that actually are providing services to victims also. So what are your rights? Well, feel free to contact us anytime if you want to know how the juvenile is progressing throughout the institutional life. If the juvenile is transferred to a less secure facility, or they're actually transferred to a more therapeutic custody level, we'll make sure you're notified as victim in that case. If they escape, we'll make sure you're notified. And of course, when they're recaptured, you will be notified. In some cases, juveniles owe money to you because of the damages they caused. Restitution. We try to provide every opportunity while they're in the institutional setting to ensure that they can pay the restitution before they're released. We provide a program where the juvenile can actually work in an industry and earn a salary. And as part of that salary, we take that money, we take a percentage of that, and we put it into an account that's transferred to the victim. Just another way that the juvenile can be held accountable for some of the things that are going on. Above all, we want you to feel safe. We want you to feel that you can exercise your rights. We have a toll-free number, and feel free to contact us at any time.
Frequently, juvenile offenders do not remain at the Department of Juvenile Justice, but instead are transferred to other facilities such as the Department of Disabilities and the Department of Mental Health. Your rights as a victim remain the same. You have the right to be notified of any transfers.
Once DJJ staff suspect that a juvenile may have a serious mental disorder, the juvenile is evaluated by a psychiatrist. If that psychiatrist finds that, in fact, the juvenile does have a serious mental disorder, that juvenile, he or she, becomes a member of the subclass. Prior to transfer to the Department of Mental Health, a staffing is held involving staff from Department of Mental Health, the Department of Juvenile Justice, Education, and any other agency that has had involvement with the juvenile. At the staffing, the purpose of the staffing is to determine, based on the juvenile's behaviors, based on the juvenile's disorder, what level of care that juvenile will need. One of the things that's taken into consideration is the prior offenses committed by the juvenile and the juvenile's behavior while at DJJ. Based on that staffing, a treatment program is identified and the juvenile is transferred within 90 days of identification. The juvenile is transferred from the Department of Juvenile Justice to a DMH treatment program or treatment program under the supervision of the Department of Mental Health. That event is the type of event which, for those individuals who've requested victim notification, will result in victim notification. In other words, the transfer of the juvenile from the Department of Juvenile Justice to a DMH treatment program will result in notification to the victim. Some subsequent events which also may result in notification to the victim would be if the juvenile runs away from the treatment program in which he's placed. In those situations, the Department of Mental Health notifies the Department of Juvenile Justice, which has responsibility for notifying victims of escapes. And running away from a treatment program is treated under the law the same as the crime of escape, just as if the juvenile had run away from the Department of Juvenile Justice institution. Another event which the juvenile involving the juvenile, which may result in notification to the victim, would be if the treatment program in which the juvenile is placed elects to give the juvenile a pass for family reunification purposes or for some other type of therapeutic purpose. Such pass cannot be granted until notification has been made to the Juvenile Parole Board, which in turn will notify the victim so that they will not be surprised if they encounter the juvenile out on pass from the treatment program. The juvenile status in the subclass remains until, as long as they're committed to the Department of Juvenile Justice. And just like other committed juveniles, they remain committed generally until released by the Juvenile Parole Board. Consequently, another event which victims who've requested notification will learn about is when the juvenile in the subclass is finally released on parole by the Juvenile Parole Board.
Juveniles who are committed to the Department of Juvenile Justice and are suspected of having mental retardation are subsequently referred to the Department of Disabilities and Special Needs. Once they're referred to the Department of Disabilities and Special Needs, we make the determination as to whether or not they are truly mentally retarded. We also look at how they are adjusting in the institution, or how they're adjusting poorly at the institution if they're not adjusting well. In order to qualify for subclass inclusion, the first thing that we look at, of course, is whether or not they are truly mentally retarded and meet the criteria for a diagnosis of mental retardation. Once their subclass to staffing is held, at that staffing are members of the Department of Juvenile Justice, the Department of Disabilities and Special Needs, Protection and Advocacy, and the Juvenile Parole Board. And at that staffing, it's determined what placement would best meet the needs for this child. And what we look at is their treatment needs, and also equally important is the security needs of this individual. Because we don't want to put an individual who may be at a risk to society in a very low management type group home. Those individuals we would want to put in a high management group home. Once the determination is made where they will be transferred, to what group home they will be transferred, the Department of Disabilities and Special Needs has 90 days to transfer that juvenile out of the institution into the placement. In the meantime, what occurs is that juvenile is transferred to a special unit at the Department of Juvenile Justice, where they receive specialized treatment until they are actually transferred out to the group home. Generally, a group home stay will be anywhere from 12 to 24 months, and a lot of that depends on what kind of progress that juvenile is making. And of course, there would be closer to the 12-month period if they are demonstrating that they're making progress, that they're receiving treatment, and it looks like that they're not as great of a risk of victimization or victimizing another individual, or going back out and committing another crime. Once that individual, it comes time for him, and he's completed the program, and it comes time for him to be discharged from the group home, we don't just throw them back home. Don't put them back in the same situation without putting them in a step-down type placement generally. And a step-down type placement would be a placement in which there's still some structure and there's still a lot of supervision, and they'll get some different types of skills to prepare them for living out on their own, or to prepare them for returning back home to a particular relative. Most often, the group homes that we use with these juveniles are what we call high management group homes. The high management group homes are highly structured, they're highly staffed, and there's great precaution taken to make sure that these juveniles are not able to escape and receive the appropriate treatment that they need. In the event that a juvenile might walk off or escape from one of these group homes, the first thing that would occur, of course, would be that local law enforcement would be notified. Also, the Department of Juvenile Justice would be notified, as well as the Juvenile Parole Board. And the Juvenile Parole Board has a victim's advocate who would in turn ensure that that individual's victim, as warranted, would be contacted to explain that this individual has walked off from this group home or has escaped from this group home.
Okay, now the juvenile has been committed to DJJ, and I'm hoping that you're going to be able to relax for a little bit. I want you to remember the most important thing at this point is that the South Carolina Board of Juvenile Parole is the sole releasing authority for all juveniles committed for an indeterminate period to the Department of Juvenile Justice. All of that just means very simply that any kid that's committed in family court for an indeterminate period cannot be released from that commitment unless they're released by the Juvenile Parole Board. Now, in trying to decide whether or not to release a juvenile, the board's going to consider three major factors. One, what's in the best interest of that juvenile. Two, what's in the best interest of public safety, particularly when you're looking at violent offenses. And three, what's in the best interest of the victim. And the board really considers how the victim feels about each particular case. A number of things will happen while the juvenile's committed to DJJ to keep you informed of the status of the case. The first thing that will happen is that the Parole Board's Victim Assistance Program, which I'm the coordinator of, we will send you a letter that will provide you information to help you understand the juvenile parole process. It will tell you how long you can expect the offender to stay in the institution. It will inform you of when hearings are scheduled and at what intervals they will take place while he or she is incarcerated. And it will also tell you what your rights are as a victim as they pertain to giving information to the board. First of all, we'll let you know that you have the right every time to appear before the board and express your opposition to release. If you choose to do that, we will escort you to and from the hearing rooms to make sure you have no contact with the offender or the offender's family. We also inform you of your right to submit written statements to the board if you so desire. That information, we will ensure, the Victim Assistance Program will ensure that that information is made accessible to the board. And then thirdly, you will be informed that you have a right to submit videotapes of your opposition statements if that's the way you would like to do it. We will work with you in any way you want to ensure that you feel safe and secure and to try to do anything we can to make you feel better about this whole horrible experience. While the juvenile is incarcerated, each time he's reviewed by the board, you will be notified in advance of that hearing, and it'll be approximately a month or so ahead of time, so to give you time to make arrangements to appear at the hearing. We will notify you of the action taken by the board each time the case is reviewed, and we'll continue that process, the notification and action reporting, until the juvenile finally gets released by the board. We will notify you when that release takes place, and that will pretty much terminate our contact with you unless the juvenile violates his parole. Should he be released and is out and he's going to have certain rules that he has to follow, if he violates any of those rules, he in fact could be brought back to the institution by the parole board's hearing officer and be scheduled for a revocation hearing. If that hearing is scheduled, we will send you a letter to notify you that the offender has been returned to the institution and that a hearing will take place and what date that hearing will take place. At that time, you'll also be informed that all of your rights that you had earlier pertaining to the other hearings are back in place if you want to appear, fine, etc. The only other thing I can think of that I would like to make sure you're aware of is that in some cases when a juvenile is released on parole, they do extremely well, and they'll have a certain period of time under which they'll be supervised. If they're doing very well, the parole officer may request that the offender be released from supervision early. In that case, we will send you again a letter notifying you that this is a request that is being made and allow you to provide input to the board. If you decide not to be involved in the process, that's fine, but we will still notify you of the outcome or what the decision is. When the Juvenile Parole Board decides to release an offender, they have a couple of options. One, which is not the most popular with victims, is an unconditional release. That would mean they leave the institution with no strings attached. I'd like to say that does happen rarely. It's not a very common occurrence. The other option is what we call a conditional release. The conditional release means that the juvenile returns to the community but has a certain number or certain rules they have to adhere to, or they could face the possibility of being revoked and returning to the institution for violating parole. Those rules could be anything from they must work, must attend school, can't violate laws, etc. Now, juveniles, victims may request some special conditions of their own. You may want to request that the offender not be allowed to return to the school that your child attends. You may request that they pay restitution. You may also request that they have absolutely no contact with you or your family. Those are things that the Victim Assistance Program can assist you in. We can get that information to the board and let them decide whether or not to make those orders. Some juveniles are released to a treatment program. Could be something, a sex offender treatment program. It could be a wilderness camp. They're actually released to that program, and they must complete the program prior to returning to the community. If they successfully complete the program, then of course they would be allowed to return to the community at that point. We do have certain cases that are not real common where a juvenile may reside out of state, and there's a process called interstate compact in which the board may release the juvenile pending a satisfactory completion of the interstate compact review to determine if the child can go and be supervised in another state, and if so, they will leave once that interstate compact has been completed.
As the chief hearing officer, my responsibility is to deal with juveniles who are on parole and possibly violating the terms of parole. Let me briefly run over that. When a juvenile has violated and the parole officer finds out about the violation, the parole officer will give me a call. We'll talk about the violation. We'll try to determine if it is serious enough to determine if the child is a threat to the community, possibly a threat to themselves, specifically if they are a threat to the victim, or if they are violating specific rules that the parole board has ordered dealing specifically with the victim's rights. If this is the case, then I'm going to direct the parole officer to issue an arrest warrant. The arrest warrant is then turned over to law enforcement. Once law enforcement picks up that juvenile, by law, I have to deal with them within 48 hours in what is termed a preliminary hearing. They have legal rights in that preliminary hearing. The victim does not need to be notified about that preliminary hearing and does not appear at that preliminary hearing. The hearing determines if there is probable cause or if, there is reason to believe that there has been a violation. If that is determined, I further detain them and refer them to the parole board. I present the information to the parole board, and I'm going to recommend that the parole board consider recommitting them to the institution. I also notify our victim assistance program that this is going on. They will notify you, the victim, and you will have an opportunity to decide if you want to address the parole board face-to-face. This may be once again that you're coming before the parole board. It might be the first time you choose to come before the parole board. You have all the options that you have had before, whether to send a videotape, appear in person, send a letter, or just let someone from the victim assistance program represent you. And of course, the Juvenile Parole Board seriously takes your position into account, and they will determine if it is serious enough for the juvenile to be recommitted to the institution. If so, then once again, guidelines are issued, and this juvenile starts over with a whole new process through the Department of Juvenile Justice.
I hope the contents of this video will help you as you navigate through the very complex juvenile justice system. Most of all, I would encourage you to use the system to move from victim to survivor. You have the right to be treated with courtesy. You have learned that you have the right to be notified by every agency that interacts with a juvenile offender that harmed you. That you have a right to fill out a victim's impact statement form. That you have a right to be present at every event in the juvenile justice process. That you have a right to speak, to express your wishes to the prosecutor, to the judge, and to the court. That you have a right to confer with the prosecution before plea bargaining. That you have a right to a safety plan if the offender is placed on probation or parole. That you have a right to restitution. That you have a right to fill out a victim's compensation form. Funeral expenses, lost wages, medical expenses, psychological counseling are some of the costs covered under the Victim's Compensation Program. That you have a right to be informed of the offender's arrest, place of incarceration, a release, or an escape. A right to attend and speak at all parole hearings. That there are many people to help you as you move through this system. Here are some of the agencies that are here to help you as well.